from Been There, Got Out, and tonight's Instagram Live welcomes back Steve Dana, Steve the Bodyguard. We've done several collaborations here and on TikTok before, so I'm really glad that I checked in with him because he's going to be talking to you from Mexico. I thought he was in New Jersey because he's originally from New Jersey. So let me just see if he's here yet. But tonight we're going to talk about restraining orders because that's a big thing that our people deal with, whether it's getting false restraining orders issued against them or trying to get a restraining order. Let's see, he's not here yet. I hope he just saw my last message. But anyway, so often people are really worried about going to court, period, but especially when they're going to get a restraining order, they often are in front of their abuser and they're confused and emotional. And so Steve said that we could talk, there he is. Okay, so we're gonna talk about, let's call it to prepare for a restraining order, what to expect when you are in court, how to handle it if it's on you. And okay, Steve, let's see, I hope you saw my thing to accept my invite. Okay, that looks like it worked now. There you go.
Hey.
So you're talking to us from Mexico.
I'm in Mexico right now.
Yeah.
Speaking of safety, right?
Right. And I'm so glad I checked with you because of the time difference. I assume that you were in New Jersey.
Yeah, and I forgot you guys went ahead an hour, and we don't go ahead an hour down here yet. I think we do at some point, but not right now.
Okay. Well, I'm so glad that you're here because I know I tried to schedule it too far in advance and then we checked closer. And so thank you for taking time out of your Mexico bliss to talk about restraining orders, one of our favorite topics.
Ah, yeah. An important topic as well, for
right.
Sure.
Yeah, and I think this came from a comment that you made on a post we did a while ago about what to expect when you go to court. And I thought, let's really narrow it down because you have so much experience in this particular area. So do you want to just introduce yourself formally for people who haven't seen any of our interviews before?
Sure. My name is Steve Dana, and I am the founder and CEO of a charitable organization called Protection from Abuse. And we provide guidance and safety and protective programs to victims of domestic violence, stalking, sexual assault, and other violent crime. And my background is I'm a bodyguard, a security professional, and right now I exist at in a very unique and turns out very rare intersection of security and victim advocacy. So one of our programs, now I'm not a lawyer, so I'd start with the following disclaimer. I am not necessarily giving legal advice, and you should always speak to a lawyer about legal advice. So I want to be real careful about that. However, I have spent conservatively hundreds of hours in court, in family court specifically, for temporary and final restraining orders as part of our Safe Access to Court program. So we actually, at least in New Jersey, we escort victims and survivors to court when they are under threat of additional violence and they're dealing with somebody particularly volatile or particularly dangerous, and we make sure that they have safe access to court. So I have a lot of court time under my belt, but I'm not a lawyer.
That's okay. It's great to have a resource, even if you're not a lawyer, but someone who's been, just like me, educated in the trenches, so you've learned a lot along the way. Yes. And I don't know if you heard me say, we usually give the harsh New York reality check. You're going to give the harsh New Jersey/Mexico reality check of what to expect with restraining orders. So before somebody even goes for a restraining order, what do you recommend that they start putting together in terms of documentation that's actually going to be effective in court? Or what other tips should they know before they even get involved in this? Because, you know, a lot of people are frightened to do a restraining order because they feel like it might be worse if they poke the bear.
And that's an important consideration, and you've asked a couple questions. So don't let me forget, but let me try to address the points that I think are really important. First and foremost, although, you know, much of our legal process can be a do-it-yourself process, Court and the law is a nuanced area. So, I think it's very important, at minimum, to connect with a local victim advocate, right? And, if we take New Jersey, for example, and many states are similar. They have county structures. You have a county prosecutor's office, and a lot of these hearings are held in the county courthouse. There is usually a victim advocate attached to each county prosecutor's office. So that is an advocate that you can connect with. They're there to help victims and survivors navigate the process. Also, the lead, or any domestic violence agency in the county, really, but I would start with the lead domestic violence agency in the county and enlist their help and guidance as well with respect to restraining orders, because, of course, they deal with that a lot. So first and foremost, you can do it. You can go it alone, and you can do it yourself. And many of those endeavors are successful. I've seen mistakes made, though, where they do not get the result that they wanted because they, either, their case didn't meet the threshold, but also because they were improperly prepared, or they didn't know what to present and what legal thresholds they needed to meet to get a restraining order. Does that make sense?
Absolutely, because I experienced that myself. The first time I tried to get a restraining order, I did it myself and didn't do it properly, and literally the next day I got help from Pace Women's Justice Center in a different state, and they wrote it up for me. They explained why they were doing it that way, and I was like, and we got it, and I thought, I wish I had known that yesterday, but luckily it was swift.
Right, and that's a valuable...
Sorry, before you go on, I think you should also note that these domestic violence services are often free. Like a victim's advocate at the court, you don't have to pay for.
Absolutely, absolutely. All the charitable and absolutely the victim advocate attached to the courts are also free. And there's also free legal programs. I can speak to New Jersey specifically because we do a lot of New Jersey work, but most states have some type of free legal clinic at a local law school, or in New Jersey, there's the Victims Law, Family Law Victim Center. I'm sure I'm screwing that name up, but that's run by a good friend of mine in New Jersey that provides free legal services all throughout the state. And those legal services are funded by the Victim Compensation Fund, which also every state has. So there are free legal services out there. And when you're talking about a restraining order, you're talking about a very finite piece of legal work, right? It's very difficult to find somebody to handle your divorce case, for instance, for free, because those are usually protracted, right? And you talk about high conflict divorces, and nobody, let's be realistic, nobody's really going to take that on for free. It's a lot of work. It's a lot of back and forth, but the restraining order process is pretty streamlined. And it's, you're looking at a pretty finite window there. So there are free legal services available. So, again, you can go it on your own, but, at minimum, you should speak to a victim advocate. You should also explore perhaps having an attorney. And we can get into why a little bit later, but, I think your experience is very instructive to a lot of your listeners who may be trying to navigate this now. They might be thinking about getting a restraining order, or they tried to get a restraining order and they were denied like you were, and they think the system doesn't work. And a lot of times, it's not that the system doesn't work, it's that you're not understanding the system and you're not navigating the system appropriately. And that's why, obviously I'm a victim advocate, but I'm a big proponent of, people having guidance. Does that make sense? Absolutely. Right. Keep going. So I think you also mentioned, right, in terms of documentation. So, I'll speak in terms of New Jersey, which I think, I don't think the various states are that dissimilar that any advice specific to New Jersey would be wildly inappropriate for any other state. But at least in New Jersey, you go, in any state, you go and you fill out the forms for your temporary restraining order. And the mistake, I'm reluctant to call it a mistake because it's a legal mistake. It's not a mistake, of the victim or the survivor, but the tendency is to go down and talk about the very last incident that led to them wanting to get a restraining order, right? And at least in New Jersey, your testimony can be limited to what you put on that temporary restraining order form. You're not going to be able to talk about some of the other, if their attorney objects or if that other opposing party objects, you're not going to be able to talk about the vast history of abuse, which of course makes your case stronger. So I always tell victims to, listen, take some time, get a piece of paper and a pen out, and start working your way backwards, right? And,
Uh-oh, Steve, wait, your volume just, okay, say the last 5 seconds. You just lost volume for 5 seconds.
Where did you lose me?
So the tendency, you said you like to recommend that people go through the history of what happened. And I was thinking, so you start with the most recent, but then you go backwards.
Yeah,
and I'm glad you said that, because sometimes people think I should go start from the beginning, like 15 years ago, and then what if you run out of time?
Right, and I think that's harder to do. And again, we're not talking criminal cases, right? This is a civil court proceeding, but the consequences for violating one have criminal repercussions. But we're dealing with a civil hearing, so you don't need exact dates and times, right? It's okay to say, in June of 2021 or last summer, et cetera, and so forth. Because what they're going to be doing is, in addition to any physical evidence or documentation you might have, they're evaluating your testimony, which really means your truthfulness, because it's a preponderance of an evidence standard, which means what's more probable than not? Are you more believable than the offender? So it's okay to be specific when you can be specific, but estimate when you can estimate, and then go back in history and start working your way back so that you can present a full case of abuse, which I think makes that restraining order stronger, if you will.
Okay. So pause for a second. I'm really glad that you noted that it's different from a criminal proceeding, which is like beyond all reasonable doubt.
Beyond
I'm guessing.
reasonable doubt.
Right. But you're saying, so even if someone doesn't remember exact specifics, and I think that's often what holds people back, because they think, well, I don't know everything perfectly, and unless I know everything, then I'm not even going to bother. You're saying it's not about that. It's about your credibility or your believability. So if you can make a good case to persuade someone that you're telling the truth and this actually happened, then you're more likely to get a restraining order.
Right. I think some people get caught up on quote unquote evidence, forgetting that your testimony is evidence, and that's evidence to be evaluated. I've seen people dissuaded or reluctant to try to get a restraining order because they never called the police, and they don't have a police report, and they think they need a police report.
Right.
You don't need a police report. All you need to do is say, last month the person, committed these offenses. And that brings me to my next point. So, we want to provide a full history so that we can make a compelling case for the restraining order. That's not to say, a one-off incident or the most recent incident is not going to be enough. I just think it's helpful in tough cases or difficult cases or contested cases, because they have a right to defend themselves, and they normally will, because the restraining order it's a serious matter. You don't want a restraining order against you, and it can have serious consequences. So you can count on it probably being contested, and you want to be able to make the strongest case that you can. But you also need to understand what the legal requirements are for the issuance of a restraining order. Now, every state is going to have some nuances, but I'll use the state that I'm in court the most often, and that's New Jersey, right? And it's basically a three-pronged test. Number one, you have to establish a family relationship. So a family relationship can be, a relative or something of that effect, or it's a former intimate partner, boyfriend, dating situation, husband, wife, that kind of thing. That's number one. Restraining orders in many states aren't issued for, hey, I want to get a restraining order against my neighbor, right? So a lot of times it's family violence that we're talking about. The next threshold in New Jersey is that you need to prove at least one predicate act of domestic violence. And the statute lists what that is. That's, even though that's a New Jersey statute, that's not going to be different than any other state. You're going to have to prove some type of offense or act of domestic violence occurred that is, included within whatever their statute is, right? And you can find these statutes, you can find these requirements online. You can, like I said, you can go it alone, you can do your quote unquote, do your research, but if you connect with a victim advocate, if you connect with an attorney, they're going to know exactly what is required, and that's why I recommend that. And then the last threshold is, just because you meet 1 and 2 doesn't mean that you necessarily need a restraining order in the eyes of the law. You have to prove, at least in New Jersey, that a continuing danger exists and that you need protection from this person. And that's why I'm a strong proponent of including, the full history. So it gives the judge a better understanding of the entire dynamics of the situation, and not just something that happened most recently that, quite frankly, a judge may look at and then hear from the defendant, and the defendant says, listen, man, I just want to go my separate way. I don't want anything to do with her. I've heard that a million times. I just want to get on with my life. I'm going to leave her alone. And some judges accept that. They don't, after speaking to the person or hearing the person testify, they conclude that, you may have been in a relationship, you may have met the requirements of the statute, but I don't think you need continuing protection from this person.
Interesting. So, I'm really glad you said that, because I think a number of our people will say this terrible thing happened and the judge just let it go.
Right.
So I'm glad you
So,
explained that.
So I'm using New Jersey to illustrate the importance of knowing the state statute and understanding what thresholds you have to meet in order for your order to be granted. Does that make sense?
Yeah, I'm thinking of what I did wrong when I went to Connecticut, because at the time it was before Jennifer's Law, and it was imminent threat of physical harm, and we didn't have that.
Right.
But the police had said go get a restraining order, so I wasn't really knowledgeable on those requirements for Connecticut. It's changed, but at the time I just had no idea.
Right.
And I didn't blame the judge for not getting it, because she explained to me why, and I thought, okay, tomorrow I'm going to do it right.
Right. But probably in the moment you thought, God, the system doesn't work. And a lot of people give up at that point. And it's not that the system doesn't work. And I'm not saying the system is perfect, right? There's no system, systems are set up to handle a large amount of cases and sift through that. And our system's pretty good at that. It's just that some cases don't fit well within the system, some cases fall through. In a lot of instances, because I'm sitting there in court, I see it every day, people didn't properly prepare their case. They don't know what's required to have something found favorably in their favor, right? And then, the other point about documentation, and again, this goes back to understanding the statute. I see a lot of testimony, and I've seen a lot of applications that are filled with, and I don't want to diminish any kind of abuse at all, no matter what it is, no matter, I don't want to assign a scale to how upsetting something might be or how severe something is. But it's important to stick to things that the law deems a reason to provide the order, right? So I want to be focused on, threats to kill, threats to harm family members, threats to harm pets, any sexual assault, and this, we could probably do a show on this just by itself, because I think a lot of women still walk around today believing that their boyfriend or their intimate partner can't sexually assault them, and it's not against the law. It's absolutely against the law. It's a behavior that is on most of your risk assessments for lethality, so we know it's a dangerous behavior. So any forced or coerced sex should be included. Obviously, any punching, shoving, slapping, et cetera and so forth. Any strangulation, any attempted choking. I mean, some people get tied up on choking, strangulation. Advocates like myself like to point out that we choke on food. When someone puts their hands around our necks and tries to cut off our blood or our airway, that's attempted strangulation, and that's the proper term. But choking, strangulation, I even spoke to somebody the other day who talked about he tries to suffocate me, during forced sex. Now, this was somebody, oddly enough, that I was speaking to that said, well, he's not really that violent. But by the time we start asking questions, right, and we start getting beneath the waterline, right, whenever we look at a problem, it always kind of appears like an iceberg, right? We only see what's above the waterline. And then when we start exploring, right, going through history, being more complete in our inventory of abuse, if you will, we start getting beneath the waterline. And we need to do that when we're presenting a legal case. We need to present a complete history. And we need to present a history that's consistent with acts that would meet what is required under whatever your state statute is for the issuance of a protection order.
Okay, so, what about stalking?
Stalking, absolutely. I think stalking is usually, I can tell you in New Jersey, stalking is a predicate act of domestic violence. Anything having to do with firearms, threats with firearms and things like that, even implied threats. And we want to be, we want to particularly mention firearms because most states, and again, it's difficult to speak in a blanketed way because I know Texas is trying to erode, taking firearms when there's an issuance of a restraining order. They may have even already successfully done that. I know there was a recent case deciding that somebody did not have to give up their firearm. But typically, a firearm seizure is fair game when there's a restraining order. So it's important to mention any firearms that are involved, any threats with firearms, and be very, at least in New Jersey, the restraining order also acts like almost like a search warrant. So it's very important to be specific where you saw the firearms. I had a case in New Jersey where they searched the home. They couldn't find the firearm. She knows that he also kept it in a vehicle, but because she did not describe or have the plate number of the vehicle, the police could not search the vehicle that was his truck, plainly on the property. So that, those are little wrinkles. There are so many little wrinkles, and I'm going to keep coming back to this and emphasizing this, that you can do it yourself, but you're better off, talking to somebody to provide you with some guidance so that you don't make these mistakes. Because obviously, the threshold for somebody to say, I need a protection order is a pretty serious one, right? I think a lot of people tolerate a lot of abuse before they get to that point, right? That's almost kind of the breaking point. And
yeah, I have an example I just thought of. I want to know what your thoughts are. So someone that we work with has a situation where they're supposed to do drop-off of the children in a public place, and the woman has asked that they do it at a midpoint, but instead her ex keeps coming over to the car and using the kids as an excuse, and then standing next to the car, even though she says, can you please not go near the car? And it keeps happening, and she's been asking him to please keep away from the car. Do you think at a certain point that might turn into a restraining order, especially because the kids are getting very uncomfortable?
So there's no existing restraining order, right?
No existing restraining order. But no, it's like that physical intimidation. But that's, I figured, let me ask you, because this comes up a lot.
Right.
Like intimidation.
That's the problem when we're talking about, it's important to know what your statute will provide relief for. And in my experience, unless it's really, intimidation is really vague. I have not seen, I'm reluctant to speak with absolutes. I don't like absolutes because I don't know the laws in all 50 states, but I'm sure there's probably some criminal statute about intimidation, but it's got to be a pretty high threshold, right?
That's really good to know. That's good to know.
Like intimidation and those type of behaviors, although quite common, I know that they're very upsetting, and I know they have the potential to escalate to damage. To danger or even violence. And I know it's a method to control people. I think we talked about this before. We talked about threats to kill. They can be very difficult to evaluate. But, if I can make you afraid of me, I can control you, right? So intimidation, is a very big deal. But I don't think by itself it rises to the level where you're going to get a restraining order for that. I do think that those things, and this is, kind of in our wheelhouse and what we really specialize in, this is something that should be included in your safety planning. Any time that you fear somebody is a danger to you, it's important to engage in safety planning. And you should do that with a professional. And unfortunately, in the landscape, safety planning is a very uneven endeavor. You've got a lot of advocates that have no background in security at all or risk management, and they're doing the best that they can. But there are published journal articles, criticizing how safety planning is accomplished, if you will, in this space. And our organization has been working for years now to change that. We're very structured in our safety planning approach, and we actually teach other advocates. And I teach a course for Rutgers School of Social Work to other advocates about safety planning. So safety planning is very important, whether you have a restraining order or not. If you get a restraining order, if you need a restraining order, you should understand that the restraining order, and we should talk about this point by itself, it's not just a piece of paper, right? I hate that expression. But a restraining order is not a blanket of protection. So if you have felt compelled enough that you have to go to get some relief from the courts to keep somebody away from you, that's enough that you should be engaging in a safety plan. So circling back to your situation, that's something that we navigate, right? The exchange of children, or any time that your life is going to intersect with an abuser or offender, you need to have strategies and you need to be able to manage those intersections in a way that you're going to be safe. That makes sense? I know that was a pretty long-winded answer to what seems like a simple question, but there's so much to unpack in a lot of these questions and a lot of these dynamics.
Yeah, definitely. I mean, each of these questions could be at least an hour in itself.
Yes.
No, but I really appreciate it. And I like that you also answered that example, because I know those are the kinds of things that we deal with a lot. Our clients deal with, and they think, oh, I can get a restraining order based on this. And it's better to tell them, no,
right.
You need more than that.
Right.
Okay, someone just asked the question, what's the difference between a restraining order and a protective or protection order?
I don't know. That would be a state-specific question. And that you may be just hearing different terms from different states. There's no distinction that I'm aware of. Every state, a lot of states have different names for it. In New Jersey, it's simply called a temporary or a final restraining order. In Pennsylvania, for example, it's called a protection from abuse order. So a lot of these terms can be used interchangeably, and unfortunately, I can't speak to every single state. But that's one area where you can definitely kind of do your own research. That information is available on the internet or various state sites or legal sites.
Yeah, in our experience, it's the same thing. It's, again, different places call it something different. Yeah. Okay, so let's talk about how someone should expect to behave in court when they go in with an application or whatever, a motion for a restraining order. What happens when they get to court? What do they do?
You're going to have a mini trial, quite literally. So let's back up for a minute. So when you fill out that initial order, that's an ex parte type process. You're filling out the forms and you're going to appear in some fashion. I don't know what they're doing still with COVID. Maybe some places are still doing video. But you are going to speak to or appear in some manner before a judge, attest to your application, and based on your testimony and what you've put in that document alone, they're going to make a ruling on your temporary restraining order. So if you've met the requirements of the statute, just very initial litmus test, your temporary is going to be granted. Then typically, and again, depending on the state, I can't quote every state, but shortly thereafter, you're going to have a hearing, at which time the offender is going to have a chance to contest the continuation of that order, right? And you're going to have quite literally and I don't want to say this to intimidate anybody. They shouldn't be intimidated by this process, although, listen, family court is not a happy place to be. I understand that. And I'm not insensitive to it. But you're going to have what amounts to a little bit of a mini trial. You're going to testify. The offender, if he shows up to defend himself, he can testify. He or his attorney can ask you questions, and you likewise can cross-examine them as well. If you have any physical evidence, photographs, police reports, screenshots of text messages, video, and things of that nature. You're allowed to present that as well. And again, this is a reason to check with a professional, or at least check with the court. A lot of judges will not accept looking at your video on your phone.
I'm just about to ask you that.
Yeah. So
we've been told they don't like it a lot of times because they don't know the whole picture.
Right. Some will. Some will handle your phone. Some won't. So check what the requirements are for evidence, in your county or wherever the courthouse is you're dealing with, because you may have to download the video or send it to them as a file or do something else with that. But it's important to check, because some judges don't look at phones or accept it on the phone. So, it's important to understand what evidence you can present and what manner you can present it in. But typically speaking, a restraining order hearing is fairly relaxed. It's not, we're not, it's still bound by legal rules and procedure, et cetera, and so forth. And you can bet if he has an attorney, and I'm going to apologize for defaulting to he, she. Men get abused too. So I'm going to say the offender. If the offender has an attorney, you can bet that the offender, they're going to be a stickler on procedure and object where appropriate and do everything that they can, fair and unfair, to win for their client, because that's what they're paying for. So it's important to be prepared. And so you're going to be able to testify, they'll testify, you submit evidence, and the judge is going to make a ruling. And it's a civil procedure. It's not beyond, it's not the criminal standard beyond any doubt. It is a civil standard. It's a preponderance of the evidence, which is more believable than the other.
Okay, let me ask you something else, because we just did an interview with a woman who was falsely arrested. She was the victim, and she got the restraining order put against her, and we have a number of clients who also have restraining orders against them. How common do you see that happening? And what do you advise? I keep asking compound questions. How common is that? And what do you advise people do to deal with that?
I don't think it's important to know how common it is, right? I know it happens enough that we need to be concerned about it. And it happens enough that we have to understand that somebody running off to get a restraining order against you can be a hit first kind of strategy to paint you as the bad guy. It doesn't stop you from trying to get your own restraining order. It doesn't stop you from defending yourself against that restraining order. But it is something you should think about if you're on the fence about getting a restraining order. Because, I think strategically it is better to be the first person. I don't know that there's a legal standard that the judge looks at or anything like that. But I just feel like if you've got a restraining order against you, and then you try, to file thereafter. And I'm not discouraging anybody to do that if they're in the right, but sometimes it looks retaliatory, right? Mm-hmm. That's not a legal burden. It's not a legal principle. Obviously, you'd have to prove it's retaliatory, and obviously the judge is going to rule on evidence. But, for my clients, I want them to, listen, if you feel like you need a protection order, if somebody, we have to first understand that once we've told somebody, I don't want to deal with you anymore, I don't want contact from you, once we've endured any kind of physical violence or threats or anything like that, or any of the number of horrible acts that I've heard throughout my seven years as an advocate, it's time to get the courts involved. It's time to go get legal protection. It's not time to sit on the fence, because those are abhorrent, abnormal, dysfunctional, and potentially dangerous behaviors.
Yeah. I was thinking of something with my own case when there's children involved, getting a restraining order for ours was weird because I wanted to get one for my daughter, not for me. And then we got the temporary, but then he got a criminal defense attorney, and they said, if you keep doing this, we're going to have your daughter testify in court. And I thought, I don't want to subject her to that.
Right. That's tricky. We're getting into legal advice. Yeah. I'll speak.
Okay, we can stop there. This is like from years ago. I just wasn't sure about it.
I think it's important because it's one of the reasons why a restraining order is not just a piece of paper, because understand that A restraining order is going to not only address you staying away from me, a restraining order is going to address who has possession of the residence, if you want to stay in the residence. And at least, you know, it's going to initially address who has custody of the children. It's not going to forbid the other parent, you know, unless you're able to get the restraining order extended to them. And this is where safety planning and there's other complications. You know, typically the parent, unless they're proven dangerous to the child, they're still going to have visitation rights. But I know in New Jersey, they can order temporary support for the household. And, you know, again, I think it's better to be first. There's no question about who has custody, at least at that moment. You're going to sort all those other things out in family court, right? That's not going to be handled entirely for a restraining order. But, you know, judges, at least I know in New Jersey, I'm not going to speak to every state, they have some flexibility to adjust those, to address those issues, and also order counseling for the offender or monitoring and, you know, other things of that nature. So, you know, I think it's important to try to address those issues. And again, if you feel like another parent is dangerous to a child, you're probably in territory. You're not, in my opinion, you're not in do-it-yourself territory. You definitely need good legal advice, particularly when children are involved.
Yeah. Okay, so we just got a question, like the average time that a restraining order is given for. So some people get it for a year, some people get it for a year and a half, some people get it for 5 years. Is there a number that you see happens most frequently?
It's different in different states. So in New Jersey, for instance, you get your temporary, and then you have that hearing, and you have what's called a final restraining order hearing. In New Jersey, final restraining orders are forever. But really? New Jersey is one of the exceptions. So again, it's going to depend on the state. You know, forever sounds great, but, you know, for people that aren't getting permanent restraining orders or restraining orders for a very long time, all hope is not lost, right? Time, the passage of time without violence and people moving on with their life, right? That's why it's important to, in these situations, attempt to resolve the conflict, get both parties, you know, get whatever shared property, get child custody, visitation, get those things behind you, because the more time that passes without violence is reassuring. Typically, the serious violence that we see, and particularly the lethality, occurs within that, you know, either very shortly after the separation or generally within a year. So as we start to, what I call, age out of that time, and we get a year, 2 years, 3 years down the line, it doesn't mean that somebody still can't be dangerous, right? It just means that typically the situations become less dangerous. And judges are aware of that. So if you have to renew an order, I think you have, you know, I think you have a, I don't want to say, you know, I'm not even sure I want to qualify it, but you're going to have to show the judge that there's a continuing need to have this order in place. So you're going to have to make some type of compelling case to show that. Because I know probably some judges don't want to just leave restraining orders out there forever. If the person has went on with their life and they're no longer a danger to the person, there hasn't been any problems, there's been no communication. So that's definitely an area, again, you know, consult with a professional, speak to an attorney, you know, find out what the requirements are. And again, you know, if you're getting free legal advice, I think that's great. If you're actually going to have to pay someone, you know, an important question before you start spending money is, based on the facts of my case, what is the most likely outcome here in your experience? And you need to know that before you start spending money. Because attorneys will happily take your money and represent you, even for a losing cause. So most of us are not independently wealthy, and particularly people that have gone through a divorce or a separation with somebody, who have experienced financial abuse. Resources are very limited, and we need to spend them very wisely. I would not recommend somebody to retain an attorney, spend thousands of dollars pursuing something that you're not going to get.
Yep, absolutely. That's, we're completely aligned with that. I mean, that's like the heart of what we do. Okay, so my last main question is, what does somebody do if the other person does not follow the restraining order? We got a call today from someone who said that her ex violated the restraining order dozens of times, and she felt like she couldn't get any assistance from the police. So what should someone like that do? Well, hopefully someone who, before it gets to that level, but
Right.
say someone violates it a couple of times, how do you handle that?
Well, you know, we're on this slippery slope of the system doesn't work, and it's not quite the system doesn't work. And that doesn't mean the system isn't broken in some ways. Police, there are very specific state requirements for when police can make an arrest. Generally, that's if they witness a crime or if there's, you know, if they have reasonable cause. So, you know, if you don't have a video of your offender driving by the house, and it's just you saying he drove by the house, or, you know, they're sending messages from a fake social media account, that's generally not enough to get somebody violated or get them arrested. That's why, you know, we're on this really troubling landscape where documentation is really your friend, and it is a process of documenting and documenting and documenting. But it's important not to give up. It's important not to think that the police don't care. It's more important to understand what is a violation, what do you need to make an arrest, or what threshold do we need to meet, what evidence do we need for there to be action taken in this situation, and then be guided accordingly, right? Does that make sense?
Yeah,
So,
yeah. I mean, the whole thing is like you keep going back. Sometimes it's not, people think, okay, they violated it once, now I've got him, he's going to be arrested, and that's going to be how it works, but it doesn't work like that.
Right. So, you know, cameras are very, you know, can be very helpful during that time. Dash cams that are recording various things, even, you know, you recording phone calls. You know, recording phone calls can be a tricky legal matter. It can violate wiretap laws, literally. But in most states, if not all states, there is an exception for prohibitions about recording calls if you think a crime is being committed. So obviously your abuser shouldn't be calling you because you have a restraining order. So I'd say you're pretty much in the clear to start recording phone calls and things of that nature. So, you know, any evidence that you can build is going to be important. I have seen repeatedly, you know, I saw him drive by my house. He's breaking the restraining order, but the police didn't see it. Or you don't have any film or anything of that. And that goes back to my earlier point. You know, it's important that we understand what threshold needs to be met for the police to actually take action. So again, you're going to want to get guidance that is specific to your state and speak to somebody to help you, guide you. But documentation, again, is your friend. You keep a log, you film when you can, you record when you can, and you document, you document, you document. You know, even if it is a situation where you don't have film, contact the police and make a report. I saw him driving down the street. So at least we're starting to build a paper trail so that when we do meet that threshold, we can say, oh, by the way, all these other things happen because now we're in court and we're testifying. So again, it's about, you know, presenting a big or more complete picture or background of what's occurring.
Yeah, we like to say establishing patterns of behavior over time.
Yes, that's very important. So, you know, don't get discouraged, you know, you know, and also don't listen to this and think that, you know, he'll never obey a restraining order, but, you know, most people obey the restraining order. And the restraining order is a very important event that helps us distinguish between those that are going to go on their way, you know, by force, you know, because by legal order and not be a problem anymore, which is the majority, or those that are going to be a potentially chronic problem. And the ones that are violating the order, those are the ones we want to take more seriously. Those are situations where you definitely want to work with a professional. You want to be hyper-focused on safety, you know, on a safety plan and risk assessment and threat assessment and understanding, you know, what's going on with this person that's repeatedly breaking the law.
Okay, I thought of one more thing. So say I have a restraining order against you, And then so you're not allowed to contact me, but then I break the restraining order and I try to talk to you and have a conversation and say, don't worry about the restraining order. Let's make up. What advice would you give to someone like you who's being solicited to break the restraining order with permission of the person who had it against you? Because in our experience, people have been tricked into breaking restraining orders and then they get in huge trouble.
Well, I'm not sure who I'm giving advice to, so I'll tell you why.
Okay.
In my experience, and again, this is not legal advice. The person with the restraining order can't break it. It's not a prohibition against them making contact. And that's going to occur, particularly when you have children together and you have to make contact through some means about visitation or something of that nature, whether it's a text message, a phone call. It may be just for a very limited purpose. Now, I had a quote-unquote offender who I'm not positive was an offender. He said the order was false and it was temporary, and every time before the hearing comes up, she drops it. But he had gotten into trouble, or she was trying to get him into trouble because she was talking to him or making contact with him, and then trying to turn around and say he broke the order because we talked on the phone.
That's what I'm talking about. Yes.
My advice is, if you have an order against you, you're not talking to them. You put it, send me an email, send me a text message so I have evidence, and better yet, have a third party. It could be, I think in his situation, it was his mom. And I said, listen, let your mom speak to this person. Let your mom, be the filter and talk about when and where you're going to meet. Hell, let your mom even meet her for the exchange, whatever it needs to be. But whatever you need to do, you need to not have any contact with her. And based on the history that you're telling me about, where this person has done this repeatedly to you or more than once, stop having contact. You can't, she's obviously manipulating the system if she's initiating contact and then turning around and saying that contact constitutes a violation, right?
Right.
But that's not,
okay.
That's not, we hear this a lot, right? We hear, well, people lie and they manipulate the system, and that's true. Not everybody that's trying to get a restraining order or goes to court or makes an allegation is being honest, but most people are, right? So,
right.
I think those are pretty exceptional situations. They don't come up a lot.
Yeah.
At least, in our advocacy, they don't come up a lot. Most people are, they got a restraining order because they are afraid and they just want to be left alone. Mm-hmm. And we try to help them.
Yeah. Okay. So I don't even know what time it is, but I feel like I've taken up a ton of your time. So how can people find you?
Our hotline is 833-657-7683. That is the best way to reach us. 833-657-7683. That's our 24-hour, 7-day-a-week hotline. And then we can connect, and typically we do a little intake, and then we may schedule a longer appointment so we can really talk and download all the information and proceed from there.
Okay.
For safety planning,
protection from abuse, right? Protection from abuse. That's the hotline.
Protectionfromabuse.org. I'm sometimes reluctant to give it out because the website is probably 5 years old at this point. It needs to be updated. We're in the middle of a massive update, and that's not done yet. So, typically we just, call the hotline. But, so for safety planning, we work nationally. In New Jersey, we have more, New Jersey, Philadelphia, New York area, we have more boots on the ground programs, like GPS searches and a taser self-defense program, safe access to court programs like that. But the safety planning we can do from anywhere.
That's great. So anywhere in the country.
Mm-hmm. Yeah. And actually, not later this year, before sometime this summer, we will be launching a platform called Oracle, which will be global, which will help advocates and victims and survivors go through the same steps that I, as a security professional, take people through to create a really comprehensive evaluation, assessment, and a safety plan with, safety steps and strategies that are actually meaningful, right? Because I think a lot of times, my major criticism of how safety planning is typically done is you kind of get a sheet of paper and, some oft-repeated advice about do this or do that. And, safety is very nuanced, it's very situational, and it's just not plug and play. So I think a lot of times people are getting a Band-Aid when they may have an hemorrhage. And, we're making sure that the people get a Band-Aid, need a Band-Aid, and the people that need something more are getting something more robust and understanding their situation better and how to stay safe.
Okay. Thank you so much, Steve. Again, I know this isn't going to be our last live interview, but thanks for taking the time.
I appreciate the opportunity. So, and then I know we had questions. I couldn't keep up with the questions. Did you want to try to circle back to any of them?
No, it's fine. Chris sent me a couple of them, but I think you covered a lot of what came through anyway that you could.
Okay. I just want to take a look at my notes and just want to make sure that I did not miss anything really important, because it's such an important deal. One thing I did want to mention, if you've dropped previous orders, I've seen people believe that, well, now I can't get an order now because I dropped one before. It's a very common behavior. And if you can explain why you dropped the order, dropping previous orders, going back with your abuser, none of those things should dissuade you from seeking protection in the future if you feel like you need protection. So that is absolutely not a reason not to go forward with an order. The other issue is, and you may have seen this because you're dealing with high conflict divorce and separation, I've seen people trade restraining orders for what's called a civil restraint. Have you heard this?
No.
Okay. So they have a restraining order. And typically, in my experience, what has happened as they wind through the divorce or, family court matters, they start to negotiate, you're negotiating various things, right? Whether it's assets, custody, things of that nature. And sometimes the restraining order gets on the table, a restraining order that's already been granted. And typically the reason is because maybe the person has a job that's affected by the restraining order.
Definitely heard this before.
Yeah, or there's a license that's affected by the restraining order. Now, this is tricky because we have to carefully weigh, even when you're first getting a restraining order, and if you're ever in this situation, you have to carefully weigh, what am I getting from this restraining order and what am I trading away? Restraining orders can absolutely make somebody more dangerous if they're going to lose their job, they're going to lose their livelihood, and you're going to put them, what we like to say, on a path to violence, right? Which is not, it's not a snap. Path to violence is not a snap. A lot of people think that that's untrue. It's a path, and it has dominoes that tend to get tipped over. So you can take somebody that's, that's already violent or has committed violence, and you can absolutely make them more dangerous. Now, I say that very carefully because I don't want, a lot of people think that if I get this restraining order, he's really going to lose it. Well, that's kind of what he wants you to believe, right? And if that were the case, nobody would get a restraining order. Those analysis, I think the victim's input is very important, but I think you definitely want to work with a professional in those situations about evaluating whether somebody's going to become more dangerous or not. I think that's a very important consideration. So I'm not shoo-shooing it at all. The vast majority of people are not as dangerous as they pretend to be. But we are concerned about the percentage that are. So you need professional guidance in that regard. But, skipping back further down the road, you may get to a point where they want a horse trade and they want you to drop the restraining order, and they're going to do what's called a civil restraint, which is not, and I'm not saying to never do it. It would be an exceptional basis for you to do it. And it has to be a really good reason why. And in my opinion, that person has to be, you cannot feel that this person is dangerous anymore. They've been a model citizen. They've obeyed the restraining order that's already in place. They've gone on in their life. Most of your conflict is resolved, and you're just looking forward to going your separate ways. So, you know, if those issues start to line up, I think it's something to consider. But understand that if that's not quite the situation, and I've seen this happen, because lawyers understand the law. They don't understand safety, security, threat assessment, risk assessment. They don't know whether somebody's dangerous or not. I mean, you would think they would if they're dealing with these issues all the time, but they're surprisingly ignorant about it. And that's not we're not bashing attorneys, it's just not their wheelhouse. Right? So I've seen people drop the restraining order that absolutely shouldn't. And now they're left with a civil document that has no teeth at all. Because unlike a restraining order, where although there's a civil standard to get the order, violations of the order are criminal. Violations of a civil restraint, right, one that you agree to civilly in family court, and you've dropped the other order, that does not have criminal consequences. It has no teeth at all.
I was going to say,
so it almost is
no
not
consequences.
Worth, what's that?
Probably very little consequences.
It has no consequences. It may have some, you know, I don't know what you can do in terms of going back to civil court and say this person violated it. So, I mean, there's no criminal recourse for that. It would be a civil recourse, and I don't even know what the remedy would be for that. So that would be something that you talk to your lawyer about if this ever comes up. But I have rarely seen a situation where this is a wise move. That's not to say never. There are definitely situations where, you know, you're not making somebody safer by taking away their livelihood. You know, because, you know, we in threat assessment circles, we like to say there's nothing more protective than having a job. We want people anchored to the system. We want people to care about consequences, right? And so when they have a job, they're, you know, normally forward-thinking, forward-looking. You know, it's how they pay their bills. You know, but when somebody can't earn a living, that could put somebody on a potentially different path. And it's, you know, it's a separate, entirely different evaluation you need to do with a professional. But I wanted to mention that because it comes up fairly frequently.
Yeah, I'm glad that you got those last couple things in there. Important. All right. So any other last things, or you think you got it?
I have 3 pages. I don't want to keep you. I think you asked a lot of great questions. And, you know, if we get enough questions or comments, we can always come back for point 2 and cover them. I mean, you know, you can spend a lot of time on something like this. And it's such an important topic that I think we should really close out on really dispelling the myths, right? That, you know, just because you dropped an order before doesn't mean you can't get it. Just because you don't have a police report or you didn't call the police doesn't mean you can't get a restraining order, right? Just because they went to get a restraining order first doesn't mean you can't go get a restraining order. No, a restraining order is not just a piece of paper. It's an important legal document that confers, you know, important rights. Is it a blanket protection of your safety? Most of the times, yes. Most offenders obey a restraining order. For that percentage that doesn't, that, you know, we need to engage in safety planning and we need to take other steps. But that does not mean that a safety, you know, that a restraining order is just a piece of paper. I hate that expression. But I understand the frustration for those that are walking in the shoes where you have somebody that just flaunts the law. A lot of times, and this goes back to your question about how do we document violations and such, a lot of times they're just tiptoeing up to the line and they're not quite crossing the line. And they're experts at flirting with the line and not crossing the line. And I understand how frustrating that can be. But none of those reasons are a reason to not get a restraining order when you need it and take advantage of the legal protections it gives you. Does that make sense?
Yeah, of course. Of course. All right. So thank you so much, Steve. And
you're welcome. Great to be here.
I know. I'll see you again. All right. Take care. Bye.